9, 19. Provisional number 19. Issues and cases over which labor arbiters have no jurisdiction. Labor arbiters have no jurisdiction over certain issues and cases. Per jurisprudence, the following issues or cases do not fall under the jurisdiction of labor arbiters. Per jurisprudence, the following issues or cases do not fall under the jurisdiction of labor arbiters. Claims for damages arising from breach of non-compete clause and other post-employment prohibitions. B. Claims for payment of cash out. So that's another loans of employees. C. Dismissal of corporate officers. D. Receivership cases. Entities immune from suit cases falling under the doctrine of non-convenience. Quasi-delicate or tort cases, criminal and civil liabilities arising from violations of certain provisions of time. Constitutionality of CBA provisions. All the foregoing issues or cases are discussed below. Usually Roman number 19-A. Claims for damages arising from breach of non-compete clause and other post-employment prohibitions. Number 1. Necessity for non-compete and other prohibitory post-employment clauses. It is customary to provide for post-employment or after employment prohibitions such as a non-compete clause in contracts of violations of employment involving key officers and personnel, which will prohibit them from engaging in the same type of business themselves or getting employed in competitor entities after the termination of their current employers. Note: see an extensive discussion on the validity of non-compete clause and other post-employment bans or prohibitions under the notes and comments on 6 post-employment found in Volume 3 of this 3-volume series on the labor code by the author. Number 2. Jurisdictional interplay between labor arbiters and regular courts. The issue of whether the labor arbiters or the regular courts of the jurisdiction to take cognizance of suits where damages arising from breach of non-compete clause has been raised in a number of cases, the most noteworthy of which are the following. Number 1. Daiichi Electronics Manufacturing Corporation versus Vidarama and Portillo versus Rudolph Leitz. Jurisdiction over employers' claim for liquidated and other forms of damages. The case of Daiichi is the best illustration of a situation where, as a consequence of the breach of the non-compete clause, the employer asserts liquidated damages against the employee. The following non-compete clause was stipulated in the employment contract. In this case, that for a period of 2 years after termination of service from employee shall not in any manner be connected and or employed by a consultant and or by an informative body directly or indirectly with any business firm, entity, undertaking, engage in a business similar to or competition with that of the employer. The case of Daiichi. Petitioner claimed that the private respondent became an employee of Angel Sound Philippine Corporation. Corporation engaged in the same line of business as that of petitioner within 2 years from January 30, 1992, the date of private respondent's resignation from petitioner's employee. Petitioner further alleged that private respondent is holding the position of head of the Material Management Control Department, the same position he held while in the employ of petitioner. Petitioner thus sought to recover liquidated damages in the amount of 100,000 pesos provided in paragraph 7 of the contract, including that the claim for damages does not arise from the petitioner, from the employer-employee relationship, and that the jurisdiction thereover belongs to the regular court. The Supreme Court reasoned as follows. Petitioner does not ask for any relief under the Labor Code of the Philippines. It seeks to recover damages agreed upon in the contract as redress for private respondent's breach of his contractual obligation to its damage and prejudice. Such cause of action is within the realm of civil law, and jurisdiction over the controversy belongs to the regular courts. More so when we consider that the stipulation refers to the post-employment relations of the parties. Number 4. Legal compensation or set-off not allowed before the labor arbiter. Legal compensation or set-off of the employers and employees' claims against each other is not allowed to be done before the labor arbiter in continuing the letter agreement between petitioner, a sales representative, and respondent. Employer contains the following non-compete clause. Prudence understood, and you agreed that on the termination of your employment by act of either you or Leeds Inc. and for a period of 3 years thereafter, you shall engage directly or indirectly as employee, manager, proprietor, or solicitor for yourself or others in a similar or competitive business, or the same character of work which you were employed by Leeds Inc. to do and perform. Should you breach this goodwill clause of this contract, you shall pay Leeds Inc. as liquidated damages the amount of 100% of your gross compensation over the last 12 months, it being agreed that this sum is reasonable and just. 3 years thereafter, or on June 6, 2005, Petitioner Portillo resigned from respondent Leeds Inc. declaring that she intended to engage in business, a rice dealership selling rice in wholesale. Respondent accepted the petitioner's resignation and reminded her that the goodwill clause in the last letter agreement she had signed. Subsequently, respondent learned that petitioner had been hired by Ed Keller Philippines Limited to head its pharma raw material department. Ed Keller Limited is purported a direct competitor of Leeds Inc. because her remaining salaries and commissions were not paid by respondent. Petitioner filed a complaint with the labor arbiter for non-payment of 1/2 month's salary, 2 months commission, 13-month pay, plus moral exemplary and actual damages and attorney's fees. Respondent admitted liability for petitioner's money claims in the total amount of 110,662.16. However, respondent raised the defense of legal compensation. Petitioner's money claim should be offset against her liability to respondent for liquidated damages in the amount of 869,633.02 for petitioner's alleged breach of the goodwill clause in the employment contract when she became employed with Ed Keller Philippines Limited. On this issue of legal compensation or offsetting of petitioner's money claims for unpaid salaries against respondent's claim for liquidated damages, the Supreme Court ruled The ruling of the Supreme Court. The claim of respondent against petitioner for liquidated damages does not arise from employer-employee relationship, nor is there any reasonable causal connection to such relationship of such claim. Hence, it falls under the civil laws and not under the labor code. The claim of respondent against petitioner liquidated damages does not arise from employer-employee relationship. The goodwill clause in this case is a post-employment issue. As such, it is a contractual undertaking effective after the cessation of the employment relationship between the parties in accordance with jurisprudence. Breach of the undertaking is a civil law dispute, not a labor law case. Breach of undertaking. Civil law dispute, not a labor law case. In the case of bar, the difference in the nature of the credits that one has against the other, conversely the nature of the debt one owes another, which difference in turn results in the difference in the forum which the different credits and being enforced prevents the application of compensation. Simply the labor tribunal in the employee is claimed for unpaid wages is without authority to allow the compensation of such claims against the post-employment claim of the former employer for breach of a post-employment condition. The labor tribunal does not have jurisdiction over the civil case for breach of contract. It is clear that a petitioner's claim for unpaid salaries is a money claim that arises out of or in connection with an employer-employee relationship. Respondent's claim against petitioner for violation of the goodwill clause is a money claim based on an act done after the cessation of the employment relationship, and while the jurisdiction of a petitioner's claim is vested in the labor arbiter, the jurisdiction of a respondent's claim rests on the regular courts. Portillo distinguished from Banez. This case of Portillo should be distinguished from Banez, where the employer was allowed to assert its counterclaim in the same case filed by the employee with the labor arbiter. This difference lies in the fact that Portillo, there is no causal connection between the petitioner-employee's claim for unpaid wages and the respondent employer's claim for damages for the alleged goodwill clause violation. Portillo's claim for unpaid salaries did not have anything to do with her alleged violation of the employment contract, as in fact her separation from employment is not rooted in the alleged contractual violation. She resigned from her employment. She was not dismissed. Portillo entitlement to the unpaid salaries is not even contested. Indeed, Leeds INC argument about legal compensation necessarily admits that it owes the money claimed by Portillo. Moreover, the alleged contractual violation did not arise during the existence of the employer-employee relationship. It was a post-employment matter, a post-employment violation. Employers' claims for cash advances, car appliance, and other personal loans of employees. Number 1. Arbiters have no jurisdiction with respect to resolving issues involving loans availed of by employees from their employers. It has been the consistent ruling of the Supreme Court that the labor arbiters have no jurisdiction thereover but the regular courts. Unilever San Miguel Corporation versus NLRC, that where the claim to the principal relief is sought to be resolved not by reference to the labor code or other labor relations statute or a CBA, but by the general civil law. General civil law, the jurisdiction over the dispute belongs to the regular courts of justice and not to the labor arbiter and the NLRC. In such a situation, resolutions of the dispute requires expertise not in labor management relations nor in wage structures and other terms and conditions of employment, but rather in the application of the general civil law. Clearly, such claims fall outside the area of competence or expertise ordinarily ascribed to labor arbiters and the NLRC, and the rationale for granting jurisdiction over such claims to these agencies disappears. Let's have a break. Relevant cases under Manual number 19-B. Relevant cases: cash loan or advances. Following San Miguel, the case of George Grothjan, GmbH and Company versus Honorable Isnani Romana Arlanchire Chinibre, declared that it is the regular court and not the labor arbiter. The regular court and the labor arbiter, which has jurisdiction to take cognizance of a cases for the collection of consequences made by the employer or made by the employee from the employer. While it is true that the loan and cash advances sought to be recovered by petitioner or contracted by private respondent Romana Lanchinibre while she was still in the employer petitioner. Nonetheless, it does not follow that Article 224 of the Labor Code covers the relationship. Not every dispute between an employer and employee holds. Notice that only labor arbiters and the NLRC can resolve the exercise of the adjudicatory or quasi-judicial powers. The jurisdiction of labor arbiters and the NLRC, the Article 224-217 of the Labor Code is limited to disputes arising from an employer-employee relationship, which can only be resolved by reference to the Labor Code, other labor statutes, or their collective bargaining agreement. This civil case is a simple collection of a sum of money brought by the petitioner as creditor against private respondent Romana Lanchinibre as debtor. The fact that they were employer and employee at the time of the transaction does not negate the civil jurisdiction of the trial court. The case does not involve adjudication of a labor dispute, but recovery of a sum of money based on our civil laws and obligation to the contract. B. Personal loan. In Food Traders House INC versus NLRC, the labor arbiter found that private respondent Barbara E. Camacho Espino's dismissal was illegal as it was without valid cause and due process. At the same time, ruling that petitioner was correct in garnishing the salary of Espino and applying the same to her personal loan. This was affirmed by the NLRC. The Supreme Court, however, ruled that the labor arbiter gravely abused his discretion when ordered the garnishment of Espino's salary for a period of 1530, January 1992, and applied the same to Espino's personal loan to petitioner's president and general manager, Orlando Aguinas. Article 224 limits the jurisdiction of labor arbiters to the cases enumerated thereunder. In the instant case, there is want of evidence that the 50,000 or 7,500 pesos, the contrary, supposing the dueness of Espino to Aguinas arose out of employer-employee relationship. On the contrary, it was admitted by both parties that Such indebtedness was a personal loan to Espino and out of the personal funds of Arenas. Clearly, this personal loan is not within the ambit of the labor arbiter's jurisdiction. C. Carlo 1. In Nestle Philippines INC versus NLRC, petitioner Nestle's demand for payment of the respondent's amortizations on their car loans or in the alternative, the return of the cars to the company was declared not a labor but a civil dispute that involves debtor-creditor relations rather than employee-employer relations. The NLRC therefore gravely abused its discretion and exceeded its jurisdiction by issuing the writ of injunction to stop the company from enforcing the civil obligation of the private respondents under the car loan agreements and from protecting its interests in the cars which by the terms of those agreements belong to the Nestle until their purchase price shall have been fully paid by the employee. The terms of the car loan agreements are not in issue in the labor case. The rights and obligations of the parties under those contracts may be enforced by a separate civil action in the regular courts, not in the NLRC. Other relevant cases are Manese vs. Jollibee Foods Corporation, where the ruling of the CA was upheld that petitioner Manese's unpaid balance on her car loan cannot be set off against the monetary benefits due to petitioner Manese has an obligation to pay the balance of the car loan to respondent Jollibee. If she cannot afford to pay the balance, she can return the car to Jollibee. Otherwise, Jollibee can file a civil case for the payment of the balance on the car loan or for the return of the car. The legal remedy of respondent company is civil in nature, arising from a contractual obligation. Number 2, Humuad versus High Flyer Food INC. The petitioner Humuad as area manager was allowed to avail of respondent's High Flyers car loan program, wherein 40% of the total loanable amount would be subsidized by High Flyer and the remaining 60% would be deducted from her salary. It was also agreed that in the event that she would resign or would be terminated prior to the full payment in full of the said car loan, she could up to surrender the car to High Flyer or to pay the full balance of the loan. Ruling that the labor arbiter has no jurisdiction over the claim. The High Court pronounced as to Humuad's claim for the reimbursement of that 40% of the total value of the car loan subsidized by High Flyer under its car loan policy. The same must also be denied. The rights and obligations of the parties to a car loan agreement is not a proper issue in a labor dispute but in a civil one. It involves the relationship of debtor and creditor other than employer-employer relations. Jurisdiction therefore lies the regular courts in a separate civil action. SPI Technologies INC versus Victoria K. Mapumo, where the labor arbiter, in addition to granting monetary awards to respondent Mapua, was dismissal due to redundancy, was declared illegal, was also awarded to her the car assigned to her by petitioner SPI Technologies. Under SPI's car plan policy, Mapua, petitioner's corporate development manager, should pay the remaining net book value of her car if she resigns within 5 years from start to her employment date. The Supreme Court, however, ruled that this subject matter is not within the jurisdiction of the labor arbiter, but in the regular courts. The remedy, being civil in nature, arising from a contractual obligation, following its ruling in several cases. 19-C. Dismissal of directors and corporate officers. We are already page 101. Transfer of jurisdiction over intra-corporate disputes from SEC to regular courts under Section 5.2 RA number 8799. The jurisdiction of the Securities and Exchange Commission over all cases enumerated under PD number 902-A has been transferred to the Courts of General Jurisdiction or the appropriate regional trial court, RTC. Madlik Doctrine. 2010 case of Matling Industrial Commercial Corp versus Ricardo Arcoros reprises the jurisdiction conundrum of whether a complaint for illegal dismissal filed by corporate officer is cognizable by the labor arbiter or by the RTC. The determination of whether a dismissed officer was a regular employee or a corporate officer unravels the conundrum. The general rule remains that in the case of a regular employee, the labor arbiter has jurisdiction. Otherwise, the RTC exercises the legal authority to adjudicate. The facts of this case are quite simple. After his dismissal by Matling as its Vice President for Finance and Administration, respondent Coros filed on August 10, 2000 a complaint for illegal dismissal against Matling and some of its corporate officers, petitioners. The petitioners moved to dismiss the complaint, raising the ground among being intra-corporate inasmuch as the respondent was a member of Matling Board of Directors. Aside from being its Vice President for Finance and Administration prior to his termination, the respondent opposed petitioners' motion to dismiss, insisting that his status as a member of Matling's Board of Directors was doubtful considering that he had not been formally elected as such, that he did not own a single share of stock at Matling, considering that he had been made to sign a blank and undated endorsement of the certificate of stock he had been given in 1992, that Matling had taken back and retained the certificate of stock in his custody, and that even assuming that he had been a director of Matling, he had been removed as the Vice President for Finance and Administration and as a director, a fact that notice of his termination dated April 10, 2000 showed. Before the Supreme Court, the principal issue presented is whether the labor arbiter of the RTC has jurisdiction considering that the respondent was a stockholder and member of Matling's Board of Directors as well as its Vice President for Finance and Administration. In resolving this issue, the following points were discussed and expounded. The law of jurisdiction in dismissal cases and labor arbiters has jurisdiction. As a rule, the illegal dismissal of an officer or other employee of a private employer is properly cognizable by the labor arbiter pursuant to Article 224A of the Labor Code as amended when RTC has jurisdiction. However, when the complaint for illegal dismissal concerns a corporate officer, the controversy falls under the jurisdiction of the RTC because the controversy arises out of intra-corporate or partnership relations. Partnership relations between and among stockholders, members, or associates, or two, between any or all of them and the corporation, partnership, or association of which they are stockholders, members, or associates respectively, and three, between such corporation, partnership, or association and the state insofar as the controversy concerns their individual franchise or right to exist as such entity, or because the controversy involves the election or appointment of a director, trustee, officer, or manager of such corporation, partnership, or association. Such controversy, among others, is known as the intra-corporate dispute. The term corporate officers refers to those mentioned in the Corporation Code and bylaws. All other officers are deemed employees. Corporate officers are elected or appointed by the directors or stockholders and are those who are given that character either by the Corporation Code or by the corporation's bylaws, batas pambansa sa bilang 69. In section 25 specifically mentions the following corporate officers, to wit, President, Secretary, Treasurer, and such other officers as may be provided in the bylaws. Thus, section 25. Corporate officers quorum immediately after their election, the directors of a corporation must formally organize by the election of a president who shall be a director, a treasurer who may or may not be a director, a secretary who shall be resident and citizen of the Philippines, and such other officers as may be provided by the in the bylaws. Any two or more positions may be held concurrently by the same person, except that no one shall act as president and secretary or as president and treasurer at the same time. Conformably with this provision, it is now the rule, according to Matley, that only the following should be considered corporate officers, those expressly mentioned in section 25, specifically the three officers which a corporation must have, namely president, secretary, and treasurer, and those expressly mentioned and provided for in the bylaws. Thus, the creation of an office pursuant to or under by law, namely provision, is not enough to take a position, a corporate office. Correa versus Lezama, the first ruling on the matter, held that only officers of the corporation were those given that character either by the corporation code or by the bylaws. The rest of the corporate officers should be considered only as employees or subordinate officials. Number 3, distinction between a corporate officer and an employee. The distinction between a corporate officer and an employee made in the case of East Hall Communication, Philippines, INC versus King, was cited by Matley. Thus, an office is created by the charter of the corporation and the officer is elected by the directors or stockholders. On the other hand, an employee occupies no office and generally is employed not by the action of the directors or stockholders but by the managing officer of the employee of the corporation, who also determines the compensation to be paid to such employee. In this case, respondent was appointed vice president, not for Nationwide Expansion by Malonzo. Petitioner is general manager, not by the board of directors of petitioner. It was also Malonzo who determined the compensation package of respondent. Thus, respondent was an employee, not a corporate officer. The CA was therefore correct in ruling that jurisdiction over the case was properly with the NRC, not the SEC, now the RTC. This interpretation is the correct application of Section 25 of the Corporation Code, which plainly states that the corporate officers are the president, secretary, treasurer, and such other officers as may be provided for in the bylaws. Accordingly, the corporate officers in the context of PD number 902A are exclusively those who are given that charter character either by the corporation code or by the corporation's bylaws. A different interpretation can easily leave the way open for the board of directors to circumvent the constitutionality is guaranteed security of tenure of the employee by the expedient inclusion in the bylaws of the enabling clause of the creation of just any corporate officer position. It is relevant to state in this connection that the SEC, the primary agency administering the Corporation Code, adopted a similar interpretation of Section 25 of the Corporation Code in its opinion dated November 25, 1993, to wit, thus pursuant to the above provision, Section 25 of the Corporation Code, whoever are the corporate officers enumerated in the bylaws are the exclusive officers of the corporation, and the board has no power to create other offices without amending first the corporate bylaws. However, the board may create appointing positions other than the positions of corporate officers, but the persons occupying such positions are not considered as corporate officers within the meaning of Section 25 of the Corporation Code and are not empowered to exercise the functions of the corporate officers, except those functions lawfully delegated to them. Their functions and duties are to be determined by the board of directors or trustees. Therefore, the power of the board of directors to create a corporate office cannot be delegated. The petitioners in Matling contend that the position of Vice President for Finance and Administration was a corporate office having been created by Matling's president pursuant to Bylaw Number 5, Officers as amended. It was held, however, that the Board of Directors of Matling could not validly delegate the power to create a corporate office to the President in light of Section 25 of the Corporation Code, requiring the Board of Directors itself to elect the corporate officers. Verily, the power to elect the corporate officers was a discretionary power that the law exclusively vested in the Board of Directors and could not be delegated to subordinate officers or agents. The office of Vice President for Finance and Administration created by Matling's president pursuant to Bylaw Number 5 was an ordinary, not a corporate office. To emphasize the power to create new offices and the power to appoint officers to occupy the requested by Law Number 5, merely allowing or allowed Matling's president to create not corporate offices to be occupied by ordinary employees of Matling. Such powers were incidental to the president's duties as the executive head of the Matling to assist in the daily operations of the business. Rulings in Tabang and Appeal no longer controlling. For a long time, the ruling in the case of Purificación versus Tabang, Purificación G. Tabang versus NLRC, has been the controlling doctrine. It was initiated therein that corporate officers dismissal is always a corporate act or an intra-corporate controversy, and the nature is not altered by the reason or wisdom with which the board of directors may have in taking such action. Also, an intra-corporate controversy is one which arises between a stockholder and the corporation. There is no distinction, qualification, nor any exemption whatsoever. The provision is broad and covers all kinds of controversies between stockholders and corporations. In this case, the petitioner's dual positions preside over dismissal of medical director and hospital administrator or private respondent Pamana, Golden Care Medical Center in Calamba, Laguna are specified under the bylaws. Matling poses the question: did respondents number 6, the status of the employee as director and stockholders? Did respondent status as director and stockholder automatically convert his dismissal into an intra-corporate dispute? The petitioner says that because the respondent was director or stockholder of Matling and Reliant Baguio versus NLRC and Ontico versus NLRC, the NLRC had no jurisdiction over his complaint, considering that any case for illegal dismissal brought by a stockholder officer against this corporation was an intra-corporate matter that must fall under the jurisdiction of the SEC, conformably with the context of PD number 902-A. In ruling of this insistence of petitioners is bereft of basis, the High Court pronounced to begin with the reliance on Baguio and Ontico is misplaced. In both rulings, the complainants were undeniably corporate officers due to their positions being expressly mentioned in the bylaws, aside from the fact that both of them have been duly elected by the two-tier test to determine whether a dispute is intra-corporate or not. In view of the declaration in Matling that the Tabang pronouncement is not controlling because it is too sweeping and does not accord with reason, justice, and fair play. Two tests. Status or relationship of the parties, relationship test, nature of controversy, test. This was the trust as early as the 1990 case of Biray versus CA. Thusly, the establishment of a. Let's have a break.